Hey, how you doing? This is Adam Post. How can the Department of Transportation of the federal government set aside $30 billion for only minority firm-owned businesses? If you can't hire or reject people based on their skin color or their gender, how can you give them $37 billion worth of contracts for that? Well, according to the courts, you kind of can't. From the Washington Post, Trump administration moves to upend $37 billion affirmative action program. The Transportation Department initiative, which serves an estimated 49,000 contractors, was a key lifeline for many minority and women-owned businesses. I'm in business. I know it can be difficult sometimes. You have up weeks, you have down weeks. It's not the same thing as having a job. And you also have up years and down years. We all went through COVID. I get all that, but you can't have a lifeline that you're getting federal contracts based on your skin color or your gender or sexual preference from the federal government, because that's not a real business. You have to compete equally with everybody else. Otherwise, you wind up in the situation where this free money and these free business deals that you didn't really earn eventually run out, and you have to then go and compete in the marketplace. And if these companies really haven't been competing effectively in the marketplace and they've been getting a lifeline and living off essentially federal government contracts, they're not going to be competitive in the real marketplace. Also from the Washington Post, minority-owned firms face crisis as affirmative action programs fall. Some cases making their way through federal courts could have catastrophic consequences for minority-owned businesses that do work for the federal government. The other thing that can happen, and likely will happen, is that the good companies, the good managers, the smart owners who own these businesses will adapt. And they may even become more successful, be able to pay their employees even more, and be more competitive. From this move alone, you could get the next wave of multi-billionaire genius business people. Adversity brings opportunity, but you can't just sit around depending on the federal government to pass you a contract that you don't really earn based on the value of what your company can offer. Because if you do that, then this happens to you. The Trump administration moved Wednesday to dismantle one of the federal government's largest and longest-standing affirmative action programs, siding with two white-owned contracting businesses that challenged its constitutionality. In a motion filed in U.S. District Court for the Eastern District of Kentucky, the Justice Department said the Transportation Department program that's carved out an estimated $37 billion for minority and women-owned businesses violates the Equal Protection Clause of the Constitution. If a judge approves the proposed settlement, the Disadvantaged Business Enterprise Program will be prohibited from awarding contracts based on race and sex, effectively ending its founding mission. Quote, over the past 5 decades, the federal government imposed a policy of race discrimination in the road building industry. That's right. It's $37 billion for their DEI-based company contracting. How much of this is actually going on throughout the federal government? It's a lot more than $37 billion. Dan Lennington, deputy counsel at the Wisconsin Institute for Law and Liberty, is representing the plaintiffs. He said this, quote, thousands of workers and small businesses have been victimized and hundreds of billions have been spent distorting the market and inflating construction costs for the taxpayers. That ends now. How is it inflating costs for the taxpayers? Well, it's inflating costs because if you've got to hire people, not based on their ability to do the job, but based on some immutable characteristic, then you've got to take whoever essentially fits that category. It doesn't mean there aren't a couple of people to choose from. It just means you can't choose from the entire market. You don't have to be competitive. And I don't know what's going on behind the scenes. I'm not involved in that industry. But in another industry, if you were, say, one of these contractors and you knew a few other contractors and you were up for the bid between a couple of you, you could collaborate and decide, okay, I'll let you get this one, you let me get that one, or subcontract to each other out of one big contract. It leaves room for a lot of potential collusion and corruption, things that should not be happening. The settlement is still subject to challenge by a coalition of businesses that intervened in the case after President Donald Trump took office, arguing that the program is essential to removing entrenched barriers that minorities and women face in the $759 billion contracting sector. First authorized by Congress in 1983, the program serves roughly 49,000 businesses designated as disadvantaged. So they steer $37 billion worth of business just to those 49,000 companies. That seems like an awful lot amount of money, even for 49,000 companies. If you divide it up, it's still a lot of money. The case was brought in 2023 by Mid-America Milling and Bagshaw Trucking, both Indiana-based transportation companies whose owners alleged they lost out on jobs when the agency began awarding contracts through the, quote, largest and perhaps oldest affirmative action program in U.S. history. And if you're running the transportation department, you've got that budget. The first thing you have to do if you're going to use that budget to award contracts to minority-owned businesses is prioritize them and prioritize the work. That becomes a whole separate project and a whole separate job. $37 billion is really a lot of money, and serving 49,000 individual vendors and trying to figure out how to give everybody work is also difficult. So you almost have to plan your contracts and plan your jobs to some extent to make work for those 49,000 contractors. That's completely inefficient because really the transportation department just needs to figure out how to get its projects done, and it doesn't need to be prioritizing based on giving people work. It needs the result of the work, the finished work, not some methodology to try to keep contractors employed. The DBE program was most recently authorized under the $1.2 trillion Infrastructure Investment and Jobs Act of 2021, as well as through the $105 billion in federal funding for airport and flight safety improvements. And as we can see, the flight safety improvements have not been going that well. Has nothing to do with minority contractors probably, but maybe it's just a bad focus because they're trying to figure out who to give work to rather than what work needs to get done and who's the most capable of doing it. In September, a U.S. district judge partially blocked the program on the grounds the plaintiffs were likely to succeed on their claims. A permanent decision was pending before the parties agreed to settle. The Disadvantaged Business Enterprise Program, which is funded by the U.S. government but administered by states, earmarks at least 10% of the federal funding for transportation infrastructure to women and minority-owned contracting firms. At the time of the ruling, the Biden administration argued that the DBE was necessary to help remedy the effects of past and ongoing discrimination in government contracting. Yeah, there seems to be discrimination, but the discrimination is you can't apply for the work unless you have a certain skin color or you're a certain gender. That's the wrong kind. You should not have discrimination in contracting. But since taking office in January, Trump has issued a flurry of executive orders seeking to end any diversity, equity, and inclusion measures by the government and beyond. The DOJ, which a few months ago defended the program under President Joe Biden, wrote in Wednesday's filing that it reevaluated its position in light of the June 2023 Supreme Court decision banning race-conscious college admissions. Even before Trump's return to the White House, a number of federal affirmative action programs had been enjoined by the courts on constitutional grounds, with plaintiffs alleging the Supreme Court's college affirmative action decision barred the government from granting benefits based on race. In September 2023, a Tennessee judge ruled that a small business administration program for minority contractors could no longer presume certain ethnic groups were inherently disadvantaged, a key requirement to receive set-asides for government contracts, such that the money and the work is set aside for those people in those contracts and set aside and provided to them in a discriminatory way based on immutable characteristics. In March 2024, a federal judge in Texas ordered the 55-year-old Minority Business Development Agency to open its doors to all, including white entrepreneurs. Those court cases were a part of a broader wave of resistance to DEI in higher education and the private sector, as well as the idea that certain racial groups are inherently more disadvantaged than others. Proponents of the DBE program and others that grant preferences based on race and sex say its loss could prove devastating for underrepresented groups in the government contracting world. Such programs were created in the 1960s and 1970s, so that was kind of like a long time ago, to address pervasive race and gender discrimination in the private and contracting sectors, the effects of which they say have not been fully erased. Supporters say many businesses will fold if the programs go away. Many businesses will be shut down if they really do depend on this money. And the next story does cover a lot of situations where the businesses really were depending on this money. They ought not to have been. But the problem is once you start taking free money, you do come to depend on it. And that's not anything to do with race or sexual preferences or gender. That has to do with just human nature. It's not good for any of us to not earn what we're getting. Minority-owned firms face crisis as affirmative action programs fall. Minority and women-owned businesses are bracing for the end of affirmative action in federal contracting. and the potential loss of contracts worth at least $70 billion a year as government programs for disadvantaged firms have fallen to legal attack over the past year. In a seismic shift, a series of court rulings have held that some of the federal government's largest diversity programs violate the Constitution's guarantee of equal protection, often citing the Supreme Court's 2023 decision to overturn race-conscious college admissions. As a result, key agencies have dropped race and gender preferences born in the civil rights era and intended to level the playing field by setting aside billions each year in contracting dollars for minority and women-owned firms. Quote, a reality has set in that it's a different game, said Tony Franco, managing partner at his company, which represents numerous minority contractors. How the government tries to achieve equality, quote, is going to require much more thinking through of how to get to disadvantaged communities of all races. This is completely not the government's business. The government can create a fair marketplace for bidding on work. There's no way for the government to bring equality to the country. We have to have a rule of law. We have to have people getting things in their lives based on merit for their benefit and the rest of the benefit of the culture. Just create a fair system that everyone participates in based on their merit. It's almost like you'd call that equal opportunity. Since the Supreme Court ruled against race-based admissions at Harvard University and the University of North Carolina at Chapel Hill, several contracting programs have suffered adverse rulings in court, including a small business administration program that funneled billions in federal contracts to disadvantaged firms. Franco said the Biden administration's decision to not appeal that SBA ruling signaled a major turning point, indicating that the administration agreed the process needed to be changed to comply with the Constitution. As a result, any programs that similarly presume minorities are disadvantaged, discriminating against everyone else, may be subject to revamping, he said. The election victory of Donald Trump, an ardent foe of affirmative action programs, is heightening fears that race-based programs could be further undone. Meanwhile, another major program is primed for a similar outcome. And that program is the Department of Transportation program we've been talking about with 49,000 contractor participants. Some say such a ruling would be catastrophic, affecting their access not only to federal contracts, but also to the many state and local programs structured exactly the same way. Quote, it would be a minority business crisis if this program went away, according to Sean Harris, owner of a Chicago-based electrical services firm. Harris, who founded his business in 2006, said it could be decimated. Though only about 10% of his company's $19 million in revenue last year came from the federal program, so around $2 million, much of the remaining income came from contracts won through the Minority Business Enterprise program run by the state of Illinois, which Harris predicted would be the next to fall. $19 million a year, guaranteed almost entirely through contracts based on people's skin color? And it doesn't sound right, and it's not right, and it's getting corrected. He's going to have to go and find some work that they're actually good and competitive at in their market and develop some new contacts and a new network, because it's ridiculous to depend on getting contracts this way. And contracts will still be there. Opportunities will still be there. Work will still need to get done. All you have to do is be competent at getting the work done. And then you get the same contracts. Unless he was getting contracts that maybe were very rich contracts or contracts you make a lot of money on that you're kind of padding the rates on. I don't know what the guy's doing. I don't see why losing one customer should really be the end of this guy's business. I've heard it happen before. But I don't see why the guy can't just go out and be competitive in his marketplace and not rely on some special advantage on every time you're going to get a contract. Quote, from an African-American contracting standpoint, it's pretty scary to think that these programs won't be around, Harris said. And to try to prepare for them is not necessarily all in our hands. It's not like the problems with bias and racism won't exist anymore. The problem is not racism and it's not reverse racism. The problem is if you really don't have a competitive firm, then you have really a scam. You don't have a real business. If you can't go out into the marketplace and do business and pay your people and make money based on your ability to actually deliver market quality and market price work, it's not a real business. And that I can't help him with. A series of Supreme Court decisions in the 1980s narrowed the circumstances in which race and gender preferences were justified. And beginning in the late 1990s, several states took up ballot measures to outlaw affirmative action. It's now prohibited in 9 states: Arizona, California, Florida, Idaho, Michigan, Nebraska, New Hampshire, Oklahoma, and Washington. California, if you can believe it, was the first state to pass a prohibition. They're often held up as an example of what lies ahead if the federal government drops its core race-conscious programs. The passage of Proposition 209 in 1996 ended the use of racial and gender considerations in government, including the awarding of state and local contracts. As a result, minority and women-owned firms secured fewer government contracts, wiping out $1 billion of their annual revenue, according to a 2015 report by the Equal Justice Society. Well, it's not equal justice to give people contracts they don't earn. More than 80% of that lost business, $823 million, was tied to state contracts, while municipalities such as San Francisco accounted for much of the rest. Quote, there were many businesses that had to close their doors because the entrenched business networks, the old boys networks that exist throughout the economy, were allowed to flourish after Proposition 209 went into effect, according to Oren Selstrom, litigation director at Lawyers for Civil Rights in Boston, who also worked as an attorney in San Francisco when the California Affirmative Action ban was passed. Quote, that is a predictor in some ways of what could happen if a similar situation unfolded at the federal level. There was and is such a thing as an old boys network of people who know each other and get each other deals and give each other contracts. And it absolutely is helpful to get multi-million-dollar contracts from the federal government as you start and you're looking to grow a business. But at some point, you can't perpetually be dependent on government contracts for your work. You have to go into the marketplace and make your connections and build your network. And if you're not capable of doing that, then you have to learn how to build a network. If you go and work for someone in a small business, medium-sized business, anywhere from, say, $1 million to $20 million a year in revenue, you will learn how everything operates in that business and also in that industry. A lot of people do that and then go on and set up their own companies. That's how you do that. You don't just say, hey, look at me. Give me a contract from the federal government because of my skin color. According to a 2009 study published in the Review of Economics and Statistics, the price of state-funded contracts in California fell 5.6% after the affirmative action ban, when compared to federally funded contracts, which were not affected by the law. The state collectively saved $64 billion in 1998 and 1999, according to the study, which attributed the savings to fewer restrictions on selecting contractors. So they could actually select people who knew how to do the work and were competent to do the work, regardless of what their skin color or their gender was, and it cost less money to get the same work done. Kendra Perkins Norwood, a partner and government contractors attorney at Reed Smith, is trying to prepare her clients for what to expect. She predicts contracting preferences across the board will no longer rely on race or gender alone. Instead, she said, qualification will come down to an individual's ability to document their struggles with discrimination. It should not be that. I hope it doesn't turn out to be that. And I would be very disappointed if it did. Could you just please give people the opportunity to do work, compensate them fairly, and then let them do work for the government and do work for private industry and build their businesses and become great at what they do? Norwood said all minority and women contractors should be preparing written narratives to prove their disadvantage. Doing so became a crucial part of the application process after a court blocked the use of racial preferences in the Small Business Administration's program. Quote, you're going to have to certainly be prepared to meet a higher standard to demonstrate why you deserve to have access to these programs, and it'll become more competitive, said Norwood, who represents disadvantaged businesses in multiple programs. Not to be too controversial, but I think the best idea is to just give people an opportunity based on what they're capable of doing. There is plenty of work to go around for everyone, but give the work to the people that are qualified to do the work, get the best work, and save the country money, because to subsidize these programs by making them go far over budget, just so you can select disadvantaged people that, what, are they disadvantaged because they don't know how to be competitive with their work? If they're really that disadvantaged, they shouldn't be running these businesses. It's simple. Just hire competent people who know how to get the job done.